I call Dennis O'Rourke.
Thank you, Mr Chairman. This bill started out with some very good intentions, and indeed there are a number of good things in it. And while there have been many worthwhile amendments, and I do think that the Select Committee did a very good job on it, there have in fact been so many amendments that the bill hardly resembles the one as introduced. The effectiveness of the family court system will, however, I think, be somewhat compromised by this bill, so it therefore remains unsupportable by New Zealand First. And there are four major reasons for that. Firstly, because the bill fails to ensure the availability of adequate publicly funded counselling when it's needed most, which is before any dispute takes hold. Secondly, because it fails to ensure that parties will have legal representation at all stages that we think they will need it. Thirdly, because legal aid will be too restricted. And fourthly, because the provisions concerning the appointment of lawyer for the child we think are far too tough. So New Zealand First will be voting against the bill. But I want to deal briefly with the SOPs at this stage, and firstly the Minister's SOP number 349. The provisions in the bill relating to the fees and expenses of a lawyer appointed to represent the child, to assist the court or appointed to write a report are amended in clause 21, so that the court may not order the parties to contribute towards the fees and expenses of a lawyer appointed to assist the court if the lawyer was appointed to provide independent advice, quote, on any complex legal issue. The words complex legal issue are highly restrictive, but also very uncertain, so that it's not easily possible to tell if this amendment will really help at all. But where complex legal issues are not the reason, and where the court appoints a lawyer to assist the court, the parties would have to pay for this, and we in New Zealand First think that is wrong. The parties should only pay for their own representation, not a lawyer appointed by the court for its purposes, whether for complex legal issues or not. There is a discretion for the court to exempt parties from this if there is serious hardship. So presumably one party might be exempted for serious hardship while the other might not be. But more importantly, serious hardship is a high bar for the purposes of exemption from the obligation to pay, and many parties will struggle to meet the costs. These costs, we think, should be met entirely by the state. So the Minister has simply not gone far enough to amend the bill in this way. However, concerning appeals, the Care of Children Act 2004, the Child Support Act 1991 and the Family Proceedings Act 1980 are amended to provide that no appeal may be made to the High Court in respect of a decision to appoint a lawyer to represent a child or assist the court, or in respect of a decision to request a person to write a cultural, medical, psychiatric or psychological report, or in respect of a direction that the parties may or may not be represented at a settlement conference. New Zealand First does support those amendments. We think those are sensible, and those are the sorts of decisions that should be made by the Family Court finally. Moving on to the Care of Children Act 2004, which is also amended so that the maximum number of counselling sessions is to be determined by regulations. We do not really know what counselling would be made available because it's simply to be set out in regulations. We suspect that counselling services will in fact be severely reduced. New Zealand First believes that a more comprehensive government-funded counselling service should be provided, and the bill repeals existing provisions for family court counselling and replaces them with a new scheme involving mandatory parenting information programs, FDR of course, and judge-directed counselling. We don't think those provisions are enough. It's clear that counselling now plays a very large role in avoiding disputes, and that needs to be enhanced, we believe, and not reduced in the way that we see with this bill. Not all families will break up if given the benefit first of counselling before any other process is used. FDR should come after counselling if counselling is not enough. The new section 46E is therefore too restrictive. The parties should be able to decide for themselves to do this without having to get a judge's direction. Finally, Mr Chairman, regarding David Clendon's SOP 254, we will be supporting that. It gives greater weight to the principle that protects the child from all forms of violence if there is any inconsistency in applying the principles in the new Section 5. Mr Clendon's amendment would insert a new Section 5(2) to provide the courts with a clear legislative guidance if the application of one or more of the other principles in the section conflicts with that principle. So I agree that subsection 5(1)(a), which says a child's safety must be protected, and in particular from all forms of violence from all persons, must be clearly, absolutely paramount and be explicitly stated to prevail over the other principles. So New Zealand First will support that SOP, but Mr Chairman, for the reasons I gave at the beginning of my address, New Zealand First will not be able to support the bill as a whole.
The Honourable Leanne Dalzell.